Hello, Namaste, Adab, Sat Sri Akal, Pranam to all. We are back again with PT 365. We were discussing issues related to the Constitution. In this video, we'll learn about Article 311, Clause 2 of the Indian Constitution. A J&K government, Jammu and Kashmir government teacher was terminated from his services without holding any enquiry. आर्टिकल 311 के रिलेटेड ये मैटर है, हम लोग आर्टिकल 311 ही देख लेते कंप्लीट. आर्टिकल 311 टाइटल्ड डिसमिसल, रिमूवल और रिडक्शन इन रैंक ऑफ पर्सन्स एम्प्लॉयड इन सिविल कैपेसिटीज अंडर द यूनियन और अ स्टेट. ये उस एम्प्लॉय की बात करता है, एम्प्लॉय की डिसमिसल, रिमूवल और रिडक्शन ऑफ रैंक के साथ डील करता है जो सिविल कैपेसिटीज के अंडर यूनियन या स्टेट के अंडर आते हैं. क्लॉज 1 says no person who is a member of a civil service of the union or an all India service or a civil service of a state or holds a civil post under the union or a state shall be dismissed or removed by an authority subordinate to that by which he was appointed. जो जिस अथॉरिटी ने अपॉइंट किया था उससे सबऑर्डिनेट अथॉरिटी उस एम्प्लॉय को डिसमिस या रिमूव नहीं कर सकती. No such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. That person, an employee, should not be dismissed or removed or reduced in rank until and unless there is an inquiry in which he has been informed. He has to be informed about the charges against him and he must be given a reasonable opportunity of being heard. Clause 3 says, which provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making representation on the penalty proposed. Which provided further that this clause shall not apply. Subclause A says where a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on a criminal charge. These are the exceptions or reasonable restrictions in these articles. The first one is the ground of conduct which has led to his conviction on a criminal charge. Subclause B, where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded by the authority in writing, it is not reasonably practicable to hold such inquiry. The authority who appointed him has the authority who is empowered to dismiss or removal of that person must be satisfied and it should be given in writing by that authority that it is not reasonably practicable to hold such inquiry. Subclause C says where the president or the governor, as the case may be, is satisfied that in the interest of the security of the state is not expedient to hold such inquiry. President or the governor should be satisfied and holds that this is not reasonable to hold this inquiry. If in respect of any such person as aforesaid, a question arises whether it is reasonably practicable to hold such inquiry as is referred to in clause 2, the decision thereon of the authority empowered to dismiss or remove such person or to reduce him in rank shall be final. The authority who is empowered to dismiss, his decision will be the final one. Let's read what is given here. Article 311 clause 2 mandates prior inquiry before dismissal, removal or reduction in the rank of government employees. And however, Article 311 clause 2 subclause C provides that no prior inquiry is required if the president or governor is satisfied that in the interest of the security of the state, it is not expedient to hold such an inquiry. We'll see in another video about foreigners tribunals, and we'll end this video here. Thank you guys. Have a good day.